This is case 2012-0598, Kenneth J. Doerr et al. Versus Philip Tuomala et al.
May it please the court, I'm Joshua Gordon. I represent Evelyn and Kenneth Doerr, and Mr. Doerr is here this morning. First, I want to address the road driveway issue, which I think is the biggest issue in the case. And the deed has 5 conditions for this road to be declared a driveway under the deed, and it's easement C, right in the middle that we're talking about. First, it's not purely personal. Chalet Pearl could use it. Second, it's not solely for ingress and egress. It doesn't go to any building. Rather, it traverses the land. And John Bush was the prior owner was a buffalo farmer. That's in his deed, and he wanted to develop the land. And this was a farm road.
Can I just ask? I'm just curious, trying to sort through the parties' positions. Your client has land that is not contiguous to this parcel.
Correct.
And so could you just tell me why it is that your client wants to be able to use this way, whatever it's called?
He wants to ride his horses around in a long loop.
I see. Okay. All right. So, and let me ask a further clarification. The original way was moved at some point.
Correct.
Do you take the position that even the original way was also a roadway and not a driveway?
Yes.
So it doesn't really matter that he moved it?
Yeah, that's correct.
Okay.
There's some additional justification for being a driveway once it went further away from Mr. Tuomala's house, but it just went further away from his house.
So that's not going to govern our analysis,
Correct.
The movement of it. Okay, good.
So this thing doesn't go to any building. It doesn't match our general sense in, like, the California case I cited of what a driveway is.
Of course, this is landlocked. This parcel is landlocked. So I suppose there's not going to be much that's regarded as a driveway.
I think the driveway is the small piece, and it's brown on that map, that goes from easement C to the Tuomala's house. That is the conventional sense of a driveway. It goes from the road to the house.
Oh, I see. There's another way that connects this disputed way to the house.
Yes.
So your position is that the driveway has to be limited to this roadway that extends from easement C to the house.
That's
but
right.
Easement C itself can't be regarded as a roadway, as a driveway.
That's right. And there are some other driveways on the land. I think there's a small way that leads to the gravel pit on easement A, and that is similarly a driveway. It's for use of the woodlands on the land.
Could you respond to the cross appeal? I know our time is limited to the cross appeal, which alleges that the court made a mistake in its ruling on summary judgment by concluding that the plain language of your client's deed granted them a right-of-way across this land.
Well, I think it...
He says if it's not contiguous, they didn't have a right.
But that's just not the language of the deed. The deed says that rights-of-way, that you don't have to be contiguous, that the rights-of-way shall not be limited to the land being herein conveyed at that time, but shall be extended and may be used in conjunction with other land presently owned by the What do you say about
your opponent's point that, and I realize that this is we're sort of really getting into the nitty-gritty, but he makes the point of it says lands when it talks about that in that last clause. It says lands plural. Whereas it said land and land in the, existing land, future land, And then in the last clause, it talks about lands.
That's a creative argument. Number one, it was never raised in the trial court. Number two, there's so many errors in this one paragraph that I think that's a hard thing to pin this on. And third, right before that plural, if it's a plural, lands, is a whole list of land of people. It's assigns and I can't remember the whole list. 7 of them I counted. And it's most logical, reading that paragraph, that plural, if it's a plural and not a possessive, refers back to the long list right before. And that's the argument I made in one of my reply briefs.
What about the trial court's finding? She took a view.
Yes.
And she found that easement C is purely for personal use, and that the Chalet Pearls, the declaration in that deed is irrelevant to her analysis. I think I'm being fair. Isn't that what she said?
The judge took a view, obviously, but I don't think that answers the question. It's purely personal, maybe in actuality, because the Tuomalas have been scaring everybody away from it for all these years. But that doesn't take away Mr. and Mrs. Doerr's deeded rights to use the thing.
Do other parties have the same deeded rights as as your client?
Yes,
under
but
your
only
view here?
A small number. I think 2 or 3.
So they would have the right to cross easement C whether you prevail or not, is that right? Or only if you prevail?
Well, they are not parties, so
Right.
as a technical matter, maybe it doesn't, but I think once...
If we
I
sustain the
prevail,
lower
perhaps
court's
they do.
ruling, she's found it to be a driveway. So no one would be able to use it, presumably.
Presumably, although nobody else, Chalet Pearl or any of the other people, nobody is a party, so
Right.
that's a technical matter, perhaps.
But the logic would apply.
Yeah.
Your light is on.
Thank you, Your Honor.
And please the court, my name is Tom Pappas, and I represent the appellees, Don and Philip Tuomala, and Don Tuomala is with us today.
Mr. Pappas, do you agree with that last point, that if Mr. Gordon's clients prevail, or that if your clients prevail, that the roadway would not, or the
Driveway.
easement C would not be available for use for other parties as well?
Yes. And first, I would note that the composite map in front of you, as we indicated in our brief, was not in evidence at trial. It has some enhancements that the evidence maps have, so I'd refer you to the maps that were actually evidence at trial.
Well, is there something erroneous about this?
It just enhances some of the things that,
I mean, but do you agree that it wouldn't be wrong of us to look at it just to get the big picture?
correct.
And do you also agree that the fact that easement C on the ground moved its location is
It moved.
irrelevant to our analysis?
Yes, it moved, and the trial judge noted that.
And it's irrelevant?
It is irrelevant, I believe. The arguments that you heard on driveway are simply arguing for different facts than those found by the trial.
But you know what, here's the thing I guess I don't have, that I have some problem with. Even if this was a private driveway at, you know, at the time of the Bush Convest deed, I have difficulty understanding how, because that deed says if they make later, if somebody makes later roadways, those can't, your opponent's rights would apply to those. And so the thing I'm having some trouble with is why would when you have the Chalet Pearl deed, doesn't that make, which gives Chalet Pearl some rights, and it talks about a 50-foot right-of-way, why isn't, I mean, how can that be consistent with a private driveway?
Well, because they're two different things. I think a private driveway is a private driveway. And if Mr. Bush considered, as the court found, I believe, considered the way that existed in 78 when the plan was put together and approved by the planning board to be a private driveway, then that's excluded from the easement.
No, but
And in the few, and if, and I
so
think. what
wait, so can I just, but let me just make sure I understand what you say. You're saying then that if it's a private driveway, then nobody later can turn it into an easement?
It's not part of the easement. I mean, if it's a
No,
private...
it's not, I understand it's not part of the easement then, but that deed, the Bush Comvest deed said that later parties could create other easements.
Future roads.
Future roads. And so what I'm saying is it your position that if it was a private driveway at the time of the Bush Comvest deed, it could never be changed into a road?
Not by, I suppose the only way it could be changed by a road if the owners of the property, the Tuomalas, presumably could do what they want with their property, but others could not. So that I don't think others could make that into a road, because if it was deemed to be a private driveway, it was therefore excluded from the easement grant.
And
if it's
am
excluded from
I
the-
correct that the plan, the Bush plan, didn't show any roadways in the area where your clients have their property?
Correct. It did not show any...
It didn't show a driveway, it didn't show a roadway, it didn't show an easement.
That's correct. And the only requirement of the planning board was to show roads. The planning board didn't say show driveways. The planning board said show roads. Mr. Bush did not show a road.
So what trumps? I mean, if arguably the deeds gave the Doers rights to this easement, but the plan never showed a roadway, does the plan trump over the deed?
I think the plan is strong evidence, as the trial court found, of Mr. Bush's intent or understanding that this driveway was not a road within the easement he granted, because he didn't put it on the plan. And if you look at the easement, it talks about roadways. It says, I give you an easement over roadways, not driveways. And if the planning board also required him to put roadways on the plan. And so if Mr. Bush, who himself used this driveway, because he built this cabin and used it himself, and if he didn't put it on the plan as a road, that's very strong evidence the court found that he didn't consider it a road, he considered it a driveway, getting back and forth to his cabin, and therefore not within the easement that he granted.
Right, but I guess I want to get back to, let's assume we agree with you on that. I guess the thing I want to get back to then is, though, as I understand it, the actual conveyance of the property, lot 71-1A, to your client was in conjunction with the Chalet Pearl, was as part of the Chalet Pearl deed, which created the easements DCE, right? So let's assume that it was all a private driveway up until then. If the Comvest deed gave later owners the right to create new roads, and if your client didn't own the property except as he got it by the Chalet Pearl deed, which deed created easements C, D, and E, why isn't that, and said that they were going to be 50-foot wide and all that, why isn't that the creation of an easement which inures to the benefit of your opponent?
My light on, should I answer the question?
Yeah, please, yes.
Thank you. I think there's a distinction, and I think the distinction is this. Mr. Bush created the easements to start, and granted, he said people in the future can create roads. Presumably, that says that anybody who owns the land, because you have to obviously own the land to create the road. And so what you're saying, when I gather from your question, what you're asking is, did Chalet Pearl, in fact, create a roadway that inures to their benefit? And I don't think that that's, first of all, I don't think that issue was addressed below, and I don't think that that was addressed in the factual thing, because I don't think there's any evidence below that there was any intent for Chalet Pearl to do that. So I don't think there's a factual record on that. As a hypothetical question, candidly, I hadn't thought of that question, is whether or not a subsequent owner could come along and say, I own the property, and really irrespective of the deed for Mr. Bush, as a subsequent owner saying, can I create a road in property that I own? I don't know.
And a road has to be approved by the planning board. So
Correct.
presumably, if a road is created and approved by the town, anybody can use the road.
If it becomes a public road, certainly.
Right.
But you'd have to presumably own the property in which the road is built and go through the process and approve that, which clearly didn't occur here. Here, in fact, when Chalet Pearl created these easements, they did go to the planning board, and they got approval to create that lot, but there's no public road that was created. And the court found that the use has been the same since when Mr. Bush built the cabin and used that driveway through today. That was a finding of the trial court. So I think that would tell you that what Chalet Pearl did not create a road, and therefore the court found did not change the private nature of that driveway.
Okay,
I candidly hadn't thought of the theoretical question that you posed, Justice Lynn, as to whether somebody in the future could somehow come along and create a roadway. But I don't think that's what occurred here. I think what's in front of this court is what occurred here, and on these facts, I think what occurred is Mr. Bush viewed that as his driveway. That's why he didn't put it on the plan. That's what the court found below, and that's what I think controls the issue in front of you.
All right, thank you.
Thank you.
We're in recess.